The gentleman from Prince William, Mr. Marshall.
Points of personal privilege, Mr. Speaker.
Gentleman has the floor.
Thank you very much. Mr. Speaker, today I filed a brief in Virginia versus Sebelius, an amicus brief, in support of the efforts of the Attorney General to challenge the Obamacare mandate. We did say a few things that are different than what the Attorney General had. He argued from the point that because the Obamacare mandate requiring that everybody purchase health insurance by the federal government mandate or a plan approved, he said it was unconstitutional. I agree. He said, therefore, the entire Obamacare should fall down. We argued the converse. We said the entire effort is unconstitutional on the part of the Congress. Therefore, the mandate should fall. Let me tell you what we argued that the Attorney General did not. First, we contended that Obamacare is not a constitutional regulation of commerce, which private businesses and individuals are engaged. In fact, the 1946 law forbids health insurance companies from competing in interstate commerce. But it is that Obamacare is a constitutionally impermissible government takeover of health care in which individuals are engaged in the wellness and health care businesses. Two, we demonstrate how Obamacare is actually designed to work, with the Secretary of Health actually functioning as if she were a CEO of a large corporation making management and control decisions rather than issuing government regulations. Third, we presented to the court evidence that during the budget reconciliation process, and this was missed by a lot of people, by which Obamacare became law, the Obama administration slipped into here a public option which enables the government to go into the health care business on more favorable terms and compete with private insurers. We made similar 10th Amendment claims that the Attorney General did, but we also pointed out that Obamacare will prevent individuals who seek medical care from homeopathy, acupuncture, herbal medicine, or dietary supplements, therefore violating their rights under the 9th and 10th Amendments. How do we address the technical points that the federal government has made that the Attorney General has no right even to be in this court case? We urge the court to go back to first principles of original intent as documented in the founding documents like the Federalist Papers. We pointed out the following. The state government has a right to intervene on behalf of its citizens, not as parens patriae, but as covenant-bound to her sovereign citizens to defend them against an out-of-bounds federal government. Secondly, federal courts have a duty to apply relevant principles of constitutional law, and they cannot duck this, that govern the distribution of power between the federal and state and do so without partiality.